Well, good afternoon, everybody. My name is Cordell McGarry. I work in the Department of Procurement Services in the Certification Division, and I'm pleased to be here to talk to you about our Professional Declaration of Eligibility feature for our certification program. And moving beyond that, let's talk a little bit about that. The Professional Declaration of Eligibility, or PDE, is an innovative way of allowing qualified attorneys and CPAs to review, verify, and attest that an applicant meets the requirements to become certified with the City of Chicago as a minority-owned business enterprise, MBE, or as a woman-owned business enterprise, WBE. In this sense, you take on the role of becoming a certification officer in the review and determination of eligibility for certification in the MBE or WBE programs. This program is not this process is not available for other certification programs at this time, and what I mean by that is we have several would not be eligible for DBE or our upcoming Veterans Business Enterprise program. But if you're looking for helping firms get certified as a WBE or MBE in areas of non-construction, this would be a good program to look at. The process involves a full review of all documentation, which is done by the qualified CPA or attorney, also conducting a site visit. A review of the documentation also requires at the end the attestation of recommendation for certification by a qualified professional, again, that being a licensed CPA or attorney. Who's eligible for consideration? All new applications for the MBE and WBE program. If you're non-construction or you're not involved as a supplier or distributor, you would be eligible. Again, other programs such as the DBE, BEPD, and our Veterans Business Enterprise programs at this time are not considered for certification under this process. We also require that the firm that's seeking certification has not been denied certification within the past 3 years, or have withdrawn an application that may have been submitted for certification within the past 3 years, or in fact, if you were previously certified, that you have not graduated within the past 3 years. Again, the process is for new applications. The time frame for processing, which is the unique feature about this process, is that once a file has been received by the city, after it's been reviewed by the qualified CPA and attorney, a cursory review will take place by a certification officer in-house, and a decision affirming the decision of the CPA or attorney will be made within 10 business days from the receipt of that. And that's a unique feature because our normal processing times average about 60 to 90 days depending on the completeness of the application. So that's a real good feature of this program for those that are interested in seeking a quick answer on their certification applications. So what happens next? We generally will now receive applications online, which is available at our website, www.chicago.mwdbe.com, and I'll give you that address again. You'll complete an online application supporting documentation along with the attestation by the qualified attorney or CPA. That's submitted online to our office. We will then review it, and once a decision is issued following the review, we will issue you a certification. Now, files are subject to a full scope audit at any time during the first year of the receipt of the certification of the application from the attorney. Businesses must submit on an annual basis during the certification term, which is 5 years, an annual no-change affidavit, and comply with all other program regulations with respect for continuing eligibility. Let me take a moment basically to say that the MBE and WBE programs are governed under regulations that are set up for non-construction firms, and they're also available on our website. These are the regulations that govern the program. So once you're certified as an MBE or WBE, through this process as well as our normal process, you'll be subject to those regulations. For the qualified professional that's seeking to work with us under this process, we do ask that the qualified individuals be an attorney or CPA, that they be licensed in the state of Illinois for at least 3 years, and they have not been convicted or found liable of fraud or making false statements. We ask that the individuals that are seeking to work in this process have no ownership interest or familial relationship with the applicant that they're working with, and that most importantly, they have an understanding of the non-construction MBE, WBE regulations, and all other applicable rules and regulations governing our certification programs. And again, this information is available on our website, City of Chicago Department of Procurement Services. You can go to certifications, and you'll see a list of documents which will include our regulations. The city itself does not endorse any of the licensed professionals that are involved in the process. We do not maintain a list of CPAs or attorneys that we would recommend. Again, this is something that's done totally or based upon the individuals that choose to participate. And that's it. Okay. So documentation requirements with regard to the program itself. We ask that the qualified individuals will basically provide us with a completed online application and all supporting documents that are also attached electronically to the application. There's also an affidavit, an attestation of certification eligibility, which is prepared by the CPA or attorney, and any other forms that we might need to support the application. Some forms are located on our website, again, cityofchicago.org procurement. In addition to the documentation that we're seeking to review will also be contact information regarding the professional as well as the applicant, the type of certification the applicant is seeking, such as MBE or WBE, and information regarding the ownership of the business, its employees, information regarding the facility it's operating from, financial information, which would be in the form of tax returns for a period of years, 3 years for the most part, and any licenses that may be required for the business to operate. So, for example, you may want to refer to the City of Chicago's Business Affairs and Consumers Protection section to determine whether or not your business may require a license. Some businesses may require professional licenses, but if they apply to you, then we would want to have that documentation as well. With the information that we receive, we will review basically the experience of the owners themselves in the form of resumes and their participation in professional associations, equipment that they may operate or use in operation, any leases that might cover equipment or facilities that they may be involved in. Contract information is also used for those that have been in business for a period of time to assess the company's ability to perform in the work that they're seeking to be certified in. We do look at contract information to be in the form of pending contracts, contracts within the past year or the year before that, and any and all purchase and invoice orders that represents businesses and activities that the business has been involved in. Each applicant for certification, each owner applicant must provide what we call an individual statement of ownership form, which may also require additional information regarding the owners themselves. So to give you an example, this form is required by each individual owner of a company. If it's one owner, one form. If it's 5 owners, each owner would need to complete a form itself. We generally ask for a personal net worth statement, which would also be available on our website. Another attachment referred to as attachment 5 would be the IRS form 4506T, which is a request for a copy of the transcript of your tax return. This form is used in some instances to verify information that was submitted in case there's a question regarding information that's on the return that you may give us. I mentioned earlier that files are subject to a full scope audit, and that's normally done within the first year of certification. We will come back and take a full review of the certification application that's been submitted, as well as review the firm for eligibility. And generally this will cover 100% of all of our files that have been submitted. In the event that we find that there was errors in the process that may have been performed by the attorney and or CPA and determination of eligibility, files can be subject to decertification. So for example, if it turns out that the owner perhaps did not have 51% control of the company, and that was a representation that was made at the time of certification, that can subject you to being decertified. Again, during the course of our audit, we will do reviews, and in the event that we find that there were some errors that were made, there are various types, there can be penalties that the professional CPA or attorney can be subject to. For this again, we request that you have a good understanding of the regulations for certification on non-construction firms, and they're available on our website. In the event that the scope of our audit determines that there were technical errors that have been committed that really weren't intentional, basically we will look at penalties that might range from a notice on the first strike. If it happens on let's say more than 2 occasions, you can lose your eligibility. Errors that didn't affect the certification outcome could be technical errors, which could very well consist of, for example, a tax return that wasn't signed by the owners. In that case, again, having an unsigned tax return makes it hard to establish whether or not this tax return is an accurate representation of let's say, what was actually submitted to the Internal Revenue Service. An error of that sort may not be intentional, and it may very well begin with just a notice that, hey guys, be more attentive in looking at the applications before you submit them to our office for review. There are some errors that unfortunately could be intentional, and in the event that an error has been determined to be intentional, the professional that's been involved in the certification process could lose their eligibility to continue working with us in the program. An intentional error could very well be an error that was done, well, I guess intentionally, being, for example, having someone sign an application on your behalf, or having someone prepare a personal net worth statement and it really was not signed, or information was left off the net worth statement or the application that may, in fact, cause a case for review. That can result in that's considered a serious error, and it can result in you losing eligibility. Substantive error, again, there's errors that are not intentional, and these errors could be, again, of a nature that could have an impact on certification, but they could also be deemed to be intentional and not intentional. Errors that are deemed to be not intentional of this nature are errors that did affect the certification outcome, and these are errors perhaps that could result in maybe the professional attorney or and/or CPA adopting a compliance integrity agreement with us. An example of this could very well be an instance where a Professional Declaration of Eligibility application was submitted to the city, and an individual company was involved in construction, but this was not necessarily understood by the attorney or CPA, and they recommended certification. Again, the program is not eligible for firms that are in construction, and this would not be a firm that could be certified. This would be a substantive error. But recognizing that it probably was due to a misunderstanding by the professional that was involved, it may just involve a little bit of retraining and maybe signing an integrity agreement. In the event of a second strike, the professional could be barred from the program. And proposed decertification would be sent to the applicant along with giving them a right to appeal. If an error is considered to be substantive and intentional, again, you can lose your eligibility. And a substantive error that was intentional could be a serious omission on a tax return, for example, a tax return that may have been altered to perhaps reduce the level of sales of a company in order for it to meet certain size standards. That could be a substantive error that was intentionally done to try to put the company in a position for certification. If it was determined that that did happen, again, the professional involved in that process could lose their eligibility. Okay. In cases like that, a professional of record, they can be referred to the Inspector General's office for further review and action. They could also be referred to the State Licensing Board for discipline, and will be referred to our Corporation Counsel for prosecution if it determined that it was serious enough under the city's false statements ordinance. So as you can see, it's important that the professional involved in the program, again, have an understanding of the regulations governing the program and do their best to adhere to those regulations. In the event that there are questions in the process and you want to seek help and guidance in going through the process, you can always contact our office, Department of Procurement Services. We're located at 121 North LaSalle in Suite 806. Our number is 312-744-4900. We have a staff of certification personnel available to assist you and answer any questions you might have regarding the PDE or any other certification process that we have. With respect to questions regarding application assembly, and you can also go to our area assist agencies. There are several. Most of our local chambers of commerce are members of our assist network, and they're involved and can help with understanding the certification process itself. Okay, so that sort of brings me to the conclusion of this particular presentation, but if there are any questions, I'll be more than happy to answer any of them now that you may have.
Sorry,
Oh, no problem.
I was a bit late. Going back to who's eligible, eligibility includes new applicants for this, okay? And it says no graduation within the past 3 years. What does it mean by that?
Okay, that's sort of a misnomer. Well, the emphasis is on new applicants. New applicants are definitely not eligible.
They're not eligible.
I'm sorry, forgive me. New applicants are eligible. Okay. Yes, let me say that again to be clear. New applicants are eligible for consideration under this process. As a matter of fact, it is really targeted for new applicants. In the event that you've had a firm that was previously certified, let's say several years ago, and they graduated from the program, and by graduation we mean that they achieved a certain level of success where they were no longer considered to be a small business anymore. Those businesses graduate. Let's say you've been out of the program for more than 3 years. You're coming back in, you would be considered a new applicant in that sense. But if your graduation was in the last 3 years, we wouldn't consider you to be a new applicant.
My question is, if these people are on new construction, on non-construction, can you partner with somebody who is like a civil engineer who wants to hire a minority to fulfill contractual obligations to the city? And part of that is for them to consult, to be translators and to review documents in Spanish and things like that. Is that an acceptable firm for you?
So if I understand your question, we're talking about, in terms of eligibility, firms that are non-construction or non-supplier distributor.
That wouldn't be, that'd be not, even though it might be construction and management consultants.
Okay. Again, so your question is, the firm is involved in, let's say, civil engineering.
Yes, the firm is involved in civil engineering. They want to partner for purposes of fulfilling their MBE requirements with an agency or with a company who has in its name construction and management consultants.
Okay.
But their sole purpose has nothing to do with specifically construction.
Right, so I'm repeating your question for the benefit of our audience. So we have a firm that's a contractor that's actually a civil engineering firm that seeks to partner with a prospective MBE firm that is involved in, let's say, consulting. And they may have the title construction consulting in their name. Would that be allowable? That consulting firm, if that consulting firm is not directly physically engaged in a construction trade, that would be allowable. And most consulting firms are considered to be professional service firms, so that would be allowable.
All right, good. And they would be eligible for this program. They would be eligible to be certified for this program. The construction and management company.
The construction consulting management firm would be eligible for consideration under the PDE process. Right. Yes. No problem. Yes, ma'am.
Okay, what is the term of certification? Like if I'm certified in April, what will be the end, and when will I have to research?
Okay, so your question pertains to the term of certification under our MBE program. So once you're certified as an MBE or WBE, you're certified for a period of 5 years.
Okay, within those 5 years, can someone say, well, maybe 2 years later, someone, let me buy into your business? Sure.
Okay. So your question pertains to a firm that's certified, which is certified for a 5-year period. And sometime during this 5-year period, there are changes in the ownership. Someone either bought in or someone left, for example. Your question is whether or not you'd have to come downtown to get recertified. Okay. The answer to that would be no, with respect to coming back down to being recertified. During the 5-year period that you're certified, what you're doing it for the 4-year period during the 5 years is you're filing on an annual basis what's called an affidavit of no change. And so that affidavit basically attests to there being no changes in the firm's ownership structure during that particular period. In the event that there has been a change in ownership, so in your example, someone bought into the business, of course, any changes to ownership would need to be reported to the city. So you would then report the change in ownership to our office. You would provide information regarding the nature of that change, such as, for example, if someone bought into the company, you want to provide information regarding that person that bought in. Like, for example, another individual statement of ownership form that identifies that person, and the circumstances involving their acquisition of ownership, and basically their role in the company. Now, depending on who that person is and whether or not they're an eligible individual for certification, say, for example, if they're a non-minority and they came in and bought 51% of the company, that may have a bearing on your continued certification. If they're a minority and they bought into the company and they didn't have controlling ownership, the business remains owned by minorities or women, it still may be considered eligible for certification. It's just that now the ownership structure has changed and we have to have information regarding that. So to answer the question, probably a little simpler, every year you're filing a no change affidavit or at such time there is a change, right? Until there has been a change in ownership, in which case you'll let us know.
Okay. Two questions. One, are the attorneys, can any attorney do this? Or is there some qualifications for the attorneys to do this? I notice there's qualifications here, but then it says below it, the city doesn't certify or endorse it.
Well, again, so your question there pertains to whether or not there are any qualifications for an attorney or CPA to be in the program. We do require that the attorney or CPA be adequately, properly licensed with the state of Illinois and have been practicing for a 3-year period. I mean, those are the basic components of certification. Now, they need to have an understanding of the non-construction regulations, pertaining to the program. So if we're certifying businesses as being minority or women, it's important that you understand the basis for which that's done, and that's the regulations.
And do the attorneys register for the program? Or what?
Okay, there's no registration that's required.
An attorney just simply certifies that he is qualified to do this, and therefore these people get certified. Is that right?
That's essentially it. I mean,
Okay, that's
yeah.
all. Okay. So there's no specific, an attorney or their firm or CPA firm doesn't have to register or do anything other than attest that they've been in business by affidavit, right?
Exactly. So the question.
Form for that, or do they?
So let me just restate the question. So we're saying here whether or not there are any qualifications for an attorney or CPA to participate in the program, i.e., is there a registration process? There is no registration process for the CPA and or attorney, other than the fact that they are attesting when they submit an application under this process that they meet the qualifications of being and practicing for at least 3 years. With every, let's say, recommendation that's made under this program. So what's going to happen is, let's say you're an attorney and you're representing a client under this program. The client prepares an application for certification, the attorney is reviewing it and the associated documents with that. It's going to conduct a site visit, and basically at the end of the review process, they're going to make a recommendation. So assuming that they're making a recommendation of certification, they're going to do that. They're going to complete a form, which we call an attestation of eligibility.
They do have.
Yes, there's a form available for that.
And where would these forms be?
Okay, they'll be online. They're online. Okay, no problem. Okay, any other questions? Okay, no? Well, if you come up with any questions later, please feel free to give us a call. Again, we're located at 121 North LaSalle, room 806. Our direct number is 312-744-4900. And we have several certification officers that can provide you with assistance. Again, my name is Cordell McGarry, and most certainly you can also ask for myself or, again, any certification officer that's available. So feel free to just give us a call if you have any questions down the road. McGary. Okay. All right. Well, that concludes this session. Again, thank you for coming. Look forward to hearing from you and seeing your work. Take care.
Is there another now?